Ndị be anyị ekene m unu. Anyị si ka nkonye chiri ya zelu. Anyị si n'ụbọchị nke taa dịrị na anyị na mma. Na ihe adị ka echi na echi ada agwụ agwụ. Otu anyị kwuru otu akwa ya dịrịrị. Ise. Dịka o si dị anyị chi imekunu mara na ya bụ Eastern News 24 ka anyị sikwa wee na-ewetara ya bụ ozi ọzọ dị oke mkpa gbasata maka ya bụ ife na-eme n'obodo anyị nọ n'ime ya. Anụ nwụrụ ụwa na-azụta n'ala Igbo. Dịka o si dị n'okwu o si ada gbasata maka the unveiling on the things na-eme n'obodo anyị nọ n'ime ya. Chukwu mana ụbọchị dị otu anyị adị andọ ife anyị na-ekene Chukwu na ihe niile obodo nke anyị kpọrọ na IPOB so or na eso afọndụ IPOB against Nigerian government. Alright, dịka o si dị ka agbapụ na ọsọ wetara ya bụ ozi anyị ji maka ya wee bịa. According to our Biafran activist, quote, a very big joy in Biafra land as ICC, UN, ECOWAS, AU, others agreed with Nnamdi Kanu, alright, on the quest of Biafran freedom. Yabife Kajimakia Webia, Gaya Bife, you get a drop what I feature and think again. Alright, over to you.
It's on trial because a lot of persons are concerned with what goes on in that case. It's not just Nigerians that are concerned. The international community is also keenly watching what is going on. And the only time you will know that they are seriously interested in what is going on is when there will be any problem, or probably after judgment will have been delivered. But what I see that will take place in that.
All right, see on this issue of Mazi Nnamdi Kanu's case, because is something I feel will not be over exaggerated, even if we continue to talk about it throughout the month, because this case have actually attracted so many international communities and so many international bodies. Just as you heard, from the man, speaking. The United Nations, the ECOWAS, the African Union, the ICC, so many countries are fully interested in this case. They are freaking too interested in this case. And it is a total blow for the zoo, because the Nigerian government are putting themselves more open and susceptible to all kind of disasters, because this international community have seen them to be jokers. Do not forget that Nigeria is seen as one of the most corrupt countries of the world. In fact, their own get weight, their own get levels. So coming out with this kind of whack judiciary is actually so disturbing, and it will continue to bring the country's recognition down and down and down. Nobody wants to associate with a well-known corrupt country that does not uphold the rule of law. I know there are corruptions in every other country, but not this kind of low-level corruption, to the extent that your judicial system is messed up. The biggest problem, like I always say, the Nigerian government made, and that was the biggest mistake they made, was holding Mazi Nnamdi Kanu. Now, when you watch this video from beginning to the end extensively, you will understand the reason why we had to even give this title. Watch this interview, listen to this man, then you will know that Nigeria is in total trouble concerning this case of Mazi Nnamdi Kanu. It was a very big mistake kidnapping Mazi Nnamdi Kanu, and he knows, and that is why Mazi Nnamdi Kanu has been defending himself, if you don't understand, because have you seen a woman holding a man by the balls? confidence in the woman because he knows Ojiano Nife. The man will keep on begging, and the woman in his pride will continue to squeeze. That is where Nnamdi Kanu is holding the Nigerian government. He's holding them down at a very critical, angle that these people cannot even get their grip off. The system is already destroyed. What more? Why will you continue to keep an innocent man under your custody? The world is listening, whether you like it or not, whether you believe the title or not. The world is listening. International communities are really interested in the case of Nnamdi Kanu. It's as simple as that. Take it or leave it. Now let us go straight up to the interview fully. Let us address this issue once and for all. Please, I want your full comment on this issue, and I want this video to go viral. Make sure you share this video to as many groups and platforms as possible. God bless you.
And impartiality of the judiciary. At the heart of the controversy is the National Judicial Council and NJC's inaction on Kanu's petition against Justice Nyako, which has fueled suspicion of a compromised judiciary. Kanu's lawyer, Aloy Ejimako, has accused the NJC of deliberate inaction on the petition, which was filed in September 2024. The petition alleged bias and misconduct on the part of Justice Nyako. The NJC's failure to act on the petition has raised questions about its commitment to ensuring the integrity and independence of the judiciary. As Kanu's trial continues, the spotlight is on the NJC to demonstrate its independence and impartiality. Anything less could undermine public trust in the judiciary and erode the rule of law. Will the NJC rise to the challenge, or will Kanu's trial become a litmus test for the judiciary's integrity? Only time will tell. This is the Eastern Eye. I am Alex Obodo. Welcome to the Eastern Eye here on Afia TV. It's a program that x-rays the political, social, and economic developments around us. Tonight I am joined by Honorable Mwabo Zugu. He is a constitutional lawyer and former member, Enugu State House of Assembly. Thank you so much for joining me tonight.
Thank you, Alex. Thank you, our viewers.
So, the Kanu's trial took a dramatic turn. In fact, he had to he had a few things to say after the whole saga of the court. I think we'll have that video. I will need you to listen to Kanu himself, so it doesn't sound like it's Alex Obodo saying all that. So let's have Kanu say some of the things he had to say at the court.
This is what happened. They sent her to my case so they can release or smoothen the pathway for the husband and the son. It doesn't matter if they're in the office. They are very, very corrupt. There is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against them. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning the disobedience to superior court. Supreme Court said you are biased. You are against this man. You should not have got his bail. Nigeria went to Kenya and kidnapped him. These things are the public domain. Why therefore are they insisting on buying this? A court order was entered. In that very court order, it was said very clearly that he is no more No. That she is no more going to fight. Why are they insisting? Why are they insisting? You have made yourself. Because they have no case against you. They have no case against you.
So there you have it, Honorable Mabezugu. He seemed to be complaining about a few things, but I think it will also be right for us to hear Aloy Ejimako, who is his lead counsel, to put things in proper legal perspective. Let's listen to Aloy Ejimako, Nnamdi Kanu's lead counsel. Let's listen to him.
Case, there's no way this case could have gone on anywhere, because in the first place, the court had lost jurisdiction to sit over this case since September last year. So we came here today on a limited appearance. We appeared under protest out of utmost respect for the judge and for the court, to listen to the court as to the reasons why we were invited before the same court that was recused in September last year. Nigerian public needs to understand the nature of a recusal. A recusal comes as a court order, and even non-lawyers are aware that once an order of court is made, the only way you can set it aside is to take it on appeal. Nobody appealed this order. The order is extant and subsisting, is still valid, and we were invited today to be informed about some memo from the Chief Judge that we don't even have a copy of the memo. So our submission on the record is that the court stands recused until that order is set aside.
All right, there you have it. So the recusal, Honorable Mabezugu, they are standing on that. So the same judge that said, all right, I'm taking my hands off the case, suddenly calls you to come back to the court without setting aside her earlier decision to recuse herself. Help us make sense of this. There are people, just like Barrister Aloy Ejimako has pointed out, that are not lawyers, but they understand simple English. Or is it that the legal profession, they don't use simple English that people understand?
English belongs to lawyers. Although the legal profession has a language, and that language in the main is Latin. And of course you know that Latin is the mother of all languages. Latin is the mother of English, and I'm not sure there's anybody in the world that will speak better English than lawyers. So what I'm trying to say is that we lawyers understand it, the laymen understand it as well, that when a court makes a pronouncement, the pronouncement that the court has made is an order. That order must be obeyed unless it is either overruled or it is overruled, of course, by a higher court. And if it is not overruled, that order has to be obeyed. Now, if the order is not obeyed, then somebody has committed contempt of court. So who is that you could say have committed contempt of court? In the event that the order of Honorable His Lordship, Honorable Justice Bin Tanyaku, in the event that his order is not, there are no ladies at the bar. In the event that his order is not obeyed, somebody should be held responsible for having committed contempt of court. That person should be sent to prison. Who is that could be said to have committed contempt? When a judge has made an order recusing himself, he has no jurisdiction to come back to that same matter. It's only an appellate court that can say, no, your recusal is not well founded in law. You have to continue the matter. Unless a higher court says so, I am not sure that such a presiding officer will have the right, that is to say, will have the jurisdiction to still come back and say, I want to continue. To start with, he didn't even make an order to say, I want to continue. He just wants to assume jurisdiction. Then something is wrong. Because you can't assume jurisdiction without anything happening. Yes, I agree that if a court makes an order that is null, that court can on its own remake the order. That is to say, that court can revoke the order, because ab initio the order was null, a null order. The implication of a null order is that you didn't have jurisdiction to have made the order. So if you don't have jurisdiction to have made an order, you now have jurisdiction to reverse the order, because the one you made is assumed not to have been made. That is to say, because you do not have jurisdiction, it is assumed not to have existed at all. So that in this instance, it cannot be said that His Lordship didn't have jurisdiction to have made the order that he made. He had the jurisdiction to do so. Again, it's also possible for a court has the inherent jurisdiction and the right to make an order that the court had made in certain circumstances. But there must be a pronouncement of that court saying the order no longer stands. You can't make an order and just as if nothing happened, you just say, I want to continue. Something will be obviously said to be wrong. So that the truth of the matter really is that Kanu was right.
Yeah, he pointed out another thing, which is of course that it looks like there's a conflict of interest in the case. They say that Justice Bintanyako's husband and son are standing trial for corruption, and that the only thing that's been dangled before Justice Bintanyako is to convict him. That's the only basis for the freedom of his family members. I mean, is this allegation founded?
To be frank with you, it is very difficult for me to say yes or no, because I do not have the facts, whether such thing ever existed or it does not exist. And of course, the machinery of justice is a very sacred one, and nobody in his right senses would want to drag it to the mud. And besides, I am a practicing minister in the Sacred Temple of Justice. So there is no way I can do anything that will reduce the honor of a judge, of any court. In fact, of any presiding officer of any court in Nigeria, even if the person is below the rank of a judge, magistrate, or person court member.
But if the person has done so himself, would that give you any choice? Would you be left with any choice, really? If someone who's supposed to preside over a court does it in a way that tarnishes the image of the court and even of the country?
Certainly. I have once said right here that a well-respected international body that the world does not play with, Amnesty International, had once said that the three most corrupt institutions in Nigeria are the police, the judiciary, and the legislature. In any event, it's also important for us to know that if you come anywhere in the world, to even start with, God himself holds something in great awe, that is fair hearing. God does not play with it. That was why he decided of his own volition to give Adam a fair hearing before sentencing him. And you remember that Herod also refused to sentence Jesus Christ without giving him a fair hearing. And everywhere in the world, in Nigeria, we operate the accusatorial system of criminal justice. That is to say that you accuse a man and he begins to defend himself. We don't operate the French system whereby a man is already condemned and it is now for him to tell the court why he shouldn't, the penalty should not be meted out to him. In Nigeria, it's a different matter because we operate the American system, the British system, the British that colonized us. That's accusatorial system. Now, what it means is that just exactly what Section 36 of Section 1 of the Constitution 1999 said, which is what Section 33, subsection 1 of the 1979 Constitution said, Section 22, subsection 1 of the 1960 Order in Council Constitution and the 1963 Republican Constitution also said, that is fair hearing, that in the determination of his civil rights and even criminal, that a man is entitled to be heard before any decision against him is taken. In fact, I remember very well that shortly before he was appointed by General Buhari in those days, the Federal Attorney General and Minister for Justice, Chike Ofodile, when he was addressing the Abo Mbaise High Court, also said the same thing, that consultation before decision on any issue affecting anybody is taken is a fundamental and indispensable foundation of justice. So the implication is that the fair hearing has twin pillars. The twin pillars are, the first is audio terrain patent, let the other side be heard, and the second is nemo judex in propria causa sua, that one should not be a judge in his own cause. Now, Kanu is alleging that his lordship, Honorable Justice Binta Nyaku, has become a judge in his own cause. That's the allegation of Kanu. In any event, the most important thing is that he is alleging likelihood of bias. Likelihood of bias. I am not sure I can situate what he's saying in bias itself, because you have likelihood of bias, you also have manifest bias. Now, therefore, whichever one is alleging, I think that if what he said is correct, then if it was possible for me to speak with the presiding officer, I would say that if what this man has alleged is correct, it will have been better that you recuse yourself from it, because justice is built upon confidence. The moment a man does not have confidence that he's going to get justice, whatever you do is rubbish as far as that man is concerned. Even if at the end of the day you give judgment in his favor, he still will believe that the judgment you gave is not justice, that somebody else ought to have taken over in order to give judgment in that matter, so that you'll be sure that it is justice that has been meted out. So this is very important. In fact, the courts in Nigeria and everywhere in the world agree that what is important is not substantive justice. That procedural justice is more important than the substantive justice. That is the procedure to attain the desired goal, not the goal itself. Just like Chukwuduka Akumeputa said in Nishizawa against Jetwani, that he said that the duty to do justice is substantial and fundamental, but the procedure towards attaining the desired goal is functional and subsidiary. So the question then arises: if the rules of procedure conflict with the essential duty of the court to do justice, what happens? If this happens, which one prevails? I agree that courts do not administer abstract justice, but justice according to the law, including rules of court. Rules of court are made to be obeyed, but all the same, rules should be seen to be helpful handmaids and not tyrannical and uncompromising masters. The general rule with which I'm in complete agreement is that it is undesirable to enable one party to score a technical victory over another at the expense of a hearing on merits. That's Chukwuduka Akumeputa in Nishizawa against Jetwan, was addressing the Nigerian Supreme Court. So what I'm trying to say is that the procedure towards attaining the desired goal is very important, not just the goal itself. And if if at the end of the day, Justice Binta Nyako acquits Nnamdi Kanu will still believe that justice has not been given. So the best and the proper thing with what is going on. And you see, we are human beings. We are all human beings. If assuming now that Kanu has made this accusation, if that matter continues under the current presiding officer, Kanu may even have died before justice is determined, because he will just take it that even if there would have been any mercy from the presiding officer, but looking at what he has said, that the presiding officer is going to finish him, so that justice does not, the streams of justice need to be kept pure and very, very unadulterated, and it doesn't operate in such a situation, such an atmosphere. The proper thing and the best thing is for this matter to be handed to somebody else.
All right, you talked about processes and outcomes, and a lot of people think that part of the stumbling blocks the federal government are having in this case with Kanu is the way they brought him to Nigeria through the extraordinary rendition from Kenya. Do you think that that has thrown the spanner in the works of any process they have taken to convict him?
Certainly, the procedure for in any event, looking at the Nigerian law of evidence, which we call the Bible of evidence in the courts in this country, the procedure for getting any person or getting a piece of evidence doesn't affect the admissibility of such an evidence. And under the criminal procedure law in Nigeria and under the laws of this country, the means of getting somebody to face trial will not affect it will not affect the legality of that trial. But the person, if he suffers any inconvenience or any damage out of the way the person was apprehended, that person can go to a civil court for damages. It doesn't affect the legality. It doesn't affect, the trial, yes. It doesn't affect the legality of the trial. It doesn't affect what is going to be the outcome.
Yes.
But the person can go to court.
Yes, but why do you think that Mazi Nnamdi Kanu's case is becoming this protracted? Is it for lack of evidence against him or for lack of a proper case against him?
I agree that there isn't sufficient evidence against him, that he is a political prisoner, not a criminal prisoner.
So with everything that unveiled at the courts 2 days ago, do you think that the judiciary has actually covered itself in glory, the way it had handled the Nnamdi Kanu case?
Well, you heard what the Nigerian Supreme Court said. The Supreme Court is the judicial high priesthood of our legal system. It is the be-all and the end-all of Nigerian judiciary. And the Supreme Court, from the last thing they said in respect of that matter, is not very pleased with the matter. And that should be, what the Nigerian Supreme Court has said, should be the color of Nigerian judiciary as far as that trial is concerned. That should be the official pronouncement of Nigerian judiciary on that trial. So the official pronouncement is that the Nigerian judiciary is on the right footing, on the right track, as far as that trial is concerned. And that's where I see it.
All right, this is the Eastern Eye here on Afia TV. When we take a break, when we return, we have more to talk about here on the program. Stay with us.
Go to the courts and submit whatever you're doing to the courts, and whatever the court says, the entire world will accept. So that's what it's that's the position.
From what you've seen, I mean, you're a senior lawyer. From what you've seen, do you think any other trial has taken this complexion, or is Nnamdi Kanu's trial a very peculiar one?
Well, unless probably when I don't know if I had been born when Awolowo was tried. If I had been born then, I was a Tata then. But I don't really know. There could also have been some other trials like that, but I'm not sure that I'm aware of when those things took place. But then, in democratic systems, it will be very difficult to do such a thing. In democratic systems, you see such things only in dictatorships. So, assuming the military were to be in power, but you should even know that a civilian dictatorship is worse than military dictatorship. So, during military dictatorships, that's when you get such things. And I don't know, it's only the judiciary that must make pronouncement in order to make it to be acceptable to the rest of the world, not just the Nigerian community.
Yes. Do you think that the judiciary is also on trial in Nnamdi Kanu's case?
I agree completely that the judiciary is on trial because a lot of persons are concerned with what goes on in that case. It's not just Nigerians that are concerned. The international community is also keenly watching what is going on. And the only time you will know that they are seriously interested in what is going on is when there will be any problem, or probably after judgment will have been delivered. But what I see that will take place in that thing is that at the end of the day, there may be no judgment. Somewhere down the line, the federal government will just say, the Federal Attorney General, on the basis of his powers under Section 191, subsection 1, paragraph C of the Constitution, 1999, may just say, enter what we call a nolle prosequi, saying that this man should be discharged, that the government thinks the trial should not continue. Let him go home. And the moment the Attorney General enters that will be the end of the trial. The man will be released and he'll go.
Do you think there's a fear that if Nnamdi Kanu is released, that he will go back to the reason why they captured him in the first place? Is there a possibility that could be one of the reasons they are finding ways to keep him for as long as they want?
I think that even the foetus in the womb accepts that that is the position. Because if you know you don't have any evidence against anybody, against somebody, evidence to even try him, evidence to think of convicting him, why would you keep him behind bars? The only reason is that there is something you don't want him to do, which the moment you release him, he'll start doing. Or there is somewhere you don't want him to go, which the moment you release him, he will go. And so that is the position. What is going on is that the federal government wants, the federal government is the prosecutor. And the prosecutor is the originator, not the judiciary. It's only when the prosecutor comes to the judiciary and says, this man, this, that, the judiciary will now start inquiring into it. Did the man actually do it? So, but the moment the prosecutor now says, oh, I no longer have anything against this man, that will be the end of it. And so, the point is that the federal government has an interest in keeping him out of circulation. And that's what the federal government is doing, just to keep him out of circulation. And that is all.
How do you think that is affecting the outlook of peace and security in southeast Nigeria? Because a lot of people think that the reason for every, if not all, most of the insecurity that we've witnessed in the southeast, it's because Nnamdi Kanu is being held, and all the people who are causing all the disturbance in different places in the south are saying, oh, it's because they are holding our leader. So, I mean, are you hopeful, really, that if he's released, that everything will go quiet?
I have that hope, and I also want to believe that that hope it cannot be punctured. I am thinking that the moment the man is released, there will be some tranquility in the southeast, and every form of insecurity, well, it can't be 100%, but at least a greater percentage of the insecurity that is going on in the southeast will fizzle out. Because take for instance the Monday sit at home in the southeast, and a whole lot of other things. After some time they'll tell you Nnamdi Kanu is going to court, so everybody should stay at home. Or this one, this one is today is the anniversary of this one, the day they burnt Nnamdi Kanu's house. Today is anniversary, so don't go out, sit at home. And there are a lot of people who obey, and such things. Now, the moment this man, I believe that they are doing this in order to keep the memory of the incarceration of Nnamdi Kanu alive, so that it doesn't die away, and everybody will forget him and go back to our normal businesses, and the federal government will now see a reason to keep him with them ad infinitum ad nauseam. And so, if this, I'm just reasoning that from their thoughts, they think that if they continue to keep his memory alive, that the federal government will have no alternative than to end this trial very fast.
A lot of people believe that if the Southeast governors go as one body and ask the president or plead with the president or request from the prime, whichever way, if they ask that Nnamdi Kanu should be released, a lot of people believe that it would have some weight as against what's currently going on. And do you think that will ever happen?
Well, whether it will happen, I do not know. But what I know, I had actually thought that there was a time the governors of the Southeast did something that looks like it.
They went separately. They didn't go as one.
Okay.
They had gone. They've gone. Even Saludo, they come out and say that they spoke with the president for the release of Nnamdi Kanu. Of course, naturally, nobody will show whether you are discussing with the president, which is customary. And you don't hear what you are discussing, except for the ones allowed for the press. But as Southeast Governors Forum, which holds a lot of weight, if you say, okay, we're appealing to the president to release him, and you go and visit him and make that point, a lot of people believe that that will be the real deal. That if that doesn't happen, then everything the governors are saying, nobody will believe them.
Well, it's very possible, very likely, because the truth of the matter is that unless there is a serious pressure, Nnamdi Kanu may not be released. And that pressure should come from where?
Open if I name na do no makabakwaro kina to saya bozi and join our membership. Or more information I na drop kwa ba ni do akwụkwọ diko si di gini ki wodi ku basta maka ya bifenda ni no ni do akwụkwọ no boss wuru chiketa na Eastern News 24 drop ora feature no dinke gi ka mana alogi ka madu ka ode ka mmadụ fiche gbasịta maka ya bụ ihe ndị a niile na-anụ ka o si ada ka emesịa na ụmụnne m